Hello and welcome to our Securing Your Business series. My name is Amy Morgan, Associate Vice President for Programs at the Winter Park Chamber. Whether you're watching on Zoom, on Facebook, or YouTube, welcome. We are glad you are here. We will have this recording posted on Facebook as well as on our website at winterpark.org for your viewing at a later time. I would like to go ahead and get us started by introducing the President and CEO of the Winter Park Chamber of Commerce, Betsy Gardner-Eckford.
Thank you, Amy, and thank you to our team for helping us get this webinar series out during this challenging time for our community and our members. We are so grateful to be able to deliver on our mission promise, which is to convene people and ideas for the benefit of our businesses and our community. And to do so digitally is a real privilege right now. We have so many members that have talented people delivering key services and products, and we're thrilled to be able to highlight some of them, especially our speaker here today. So our series has been focused on giving people tactical and strategic tips on how to navigate the crisis, and I'm grateful to the elected officials who've served and to some of our role modeling businesses who've made key pivot moments to create change that's required to navigate this difficult time. And today we've got a wonderful speaker. I'm really looking forward to hearing about this. Many of you have been reading that more and more people are feeling existential pressure right now and the need to be able to plan for an unknown future. And we've got some spectacular talent that you're going to hear from our speaker today, Amy Collins-Hitchner, who is an attorney at law with Swan, Hadley, Stump, Dietrich, and Spears, PA. She has been with the firm, which has local roots dating back to 1924 in Central Florida. And the firm works to protect their clients' interests in commercial and residential real estate, business formations, transactions, acquisitions, succession, estate planning, and when necessary, business litigation. Amy's practice is focused on business, estate planning, and probate. She counsels her clients to create an all-encompassing plan to protect their business assets and meet their personal goals, leaving a family legacy. Amy, welcome. We're thrilled that you're here with us today. This is a very timely topic. I know a lot of people are feeling a sense of urgency about getting things more organized, not least their closets, but also their estate planning. So thank you for being with us today.
Thank you. Thank you so much for inviting me to speak on this important topic. I think that we can all agree that pandemics are stressful. So whether it's stress about homeschooling or stress about your job or worries about friends and family and neighbors or fear of actually catching the virus, I can't help relieve all of the stresses, but I can certainly help alleviate some of your fears by offering some education about getting your personal affairs together. Because I feel like when you have a plan, you at least feel like you've got a little bit of control over just this unknown future. So getting important documents like advance directives and a will can certainly help you sleep better. So I can tell you that I'm getting questions pretty much every day about the steps to take and the steps to make sure that your decisions are made ahead of time. So I think one of the things that's coming out of this is that we're realizing that in a hospital setting now we can't have visitors. And so that's kind of a new area for us to think about. How are we going to use these documents and who's going to be able to bring them to the people that need to see them? And so that's kind of a new thing that we're addressing. So today, Betsy is going to ask me some of my most frequently asked questions. I'm going to do my best to answer them. So first, I have a quick disclaimer. Every situation is different, requires individual attention. So I'm going to answer these questions with generalities. And if you have specific questions about your situation, you should consult with your attorney. And if you don't have one, I'd be happy to assist you.
Well, you wouldn't be a very good attorney if we didn't have a disclaimer to start with, Amy. So thank you for legitimizing your presentation at the get-go. Okay, so our first question is related to healthcare. How do I make sure that someone can make medical decisions for me if I'm incapacitated and unable to make them for myself?
So that's a great and super relevant question right now. One of the most important documents that we use regularly is the designation of healthcare surrogate. So a healthcare surrogate is a person that you appoint that can stand in your shoes and make medical decisions for you. Sometimes it's called a medical power of attorney. This is an important role for many different reasons. The document tells healthcare providers that you have named a surrogate, that they can, or co-surrogates, actually, you can name people to act together to make your medical decisions. That means they can provide informed consent, refusal of consent, or withdrawal of consent for any and all of your healthcare needs. They can access payment information regarding your healthcare. They can really do anything that you can do related to your healthcare, your healthcare surrogate can also do. So how do you determine who should serve as your healthcare surrogate? Typically, spouses name each other first, and then I like to recommend that you choose at least one backup in case that the person named is unable or unwilling to serve. Oftentimes, adult children can make a good backup choice. If you don't have a spouse or adult children, family members or friends that work in the healthcare industry also make great choices. Just make sure that when you are thinking about who your surrogate is going to be, that you communicate with that person to make sure that they actually want to serve. It can be a big task. As we're going to talk about in a little bit, you're going to make a lot of the really big, heavy decisions related to like life support on your own, but your healthcare surrogate can make a lot of other really big decisions on your behalf as well, and they'll have access to all of your medical records. So it needs to be someone that you trust with making those types of decisions. So the one thing that you can choose as an option in your healthcare surrogate is for it to become effective immediately from the perspective of accessing medical records. So you can initial a section that says, I want my healthcare surrogate to immediately access records. And oftentimes that's a really important piece of this process because we want to be able to transfer medical records, and that can be one of the most challenging situations, especially if a HIPAA release has not also been executed. So that all gets incorporated into your healthcare surrogate. One other thing it's important to note is that you can revoke your healthcare surrogate at any time, and you can update it as long as you have capacity. So you still have to have your mental capabilities in order to revoke it or update it. And I like to tell my clients to think about updating your documents when major life events happen, or within around like 5 to 7 years of your original execution of your documents. So major changes in life would be a disability or a birth of a child, or those types of big changes make it a good time to look at updating. So I think I kind of started on this a little bit earlier, but historically when the healthcare surrogate was scheduled to act for you, they did so in person at the hospital or surgery center or in the doctor's office. But in the context of COVID-19, visitors are not being allowed into these treatment locations. And so if you already have a healthcare surrogate document, you may want to consider updating it so that includes language that allows your healthcare providers to communicate with your healthcare surrogate by telephone, by Zoom, by email, by FaceTime, Skype, whatever it is that you think might be appropriate. Your attorney can help you figure that out. And that your healthcare provider can rely on your surrogate's instructions directly from those devices. Some people are suggesting even that we include hold harmless for the physicians, just for that piece, for being able to talk by technology, right? So your healthcare person is also the person who is tasked with presenting a living will, if necessary.
Well, that is a perfect segue into the next question. Tell us, what is a living will and why might I need one?
So a living will is different than a last will and testament. I think sometimes I meet with clients and they're like, oh yeah, I've got my living will all together. And I take a look at their documents and I'm like, yeah, no, you've got your last will and testament, which is great. I'm so glad you have that. But you also need to have a living will. And so a living will is your personal declaration. It's just your statement of whether you want life prolonging procedures to be withheld or withdrawn in 3 situations. Those 3 situations are a terminal condition, an end-stage condition, or a persistent vegetative state. So we're going to go over those conditions in a minute, but first I want to explain why you need this document. So basically, if no one knows what you want, then your healthcare providers may do something that you don't want, and your family members or friends may argue over what it is they think you want. And so the best example I have of this is the Terry Schiavo case that a lot of you may remember, where a young woman, 26 years old, suffered a cardiac event that left her in a persistent vegetative state. She did not have a living will, and her husband believed that she wanted one thing, and her parents believed she wanted the opposite. And so this case wound its way through the courts for 15 years. So this poor woman was attached to life-prolonging mechanisms for 15 years while the courts decided her fate. And so ultimately the court determined that she did not want life-prolonging procedures, and they were removed. So having a living will can put a stop to these arguments. It can clearly state what you want, and neither your healthcare surrogate nor anyone else can really challenge that. So let's discuss the definitions of these 3 conditions. These terms are defined in our Florida statutes. Terminal condition means a condition caused by injury, disease, or illness from which there's no reasonable medical probability of recovery, and which without treatment can be expected to cause death. It sounds terrible, right? So it doesn't get any better from here. End-stage condition is an irreversible condition caused by injury, disease, or illness, which has resulted in progressively severe and permanent deterioration, in which to a reasonable degree of medical probability, treatment would be ineffective. So this is where all treatment options have taken place and there's nothing else that's available, and that would be what is considered an end-stage condition. Persistent vegetative state, I think, is what most people comes to mind when you're thinking of a living will, and this is a permanent and irreversible condition of unconsciousness, in which there is the absence of voluntary action or cognitive behavior of any kind, and an inability to communicate or interact purposefully with the environment. So that is a mouthful. The next thing most everyone asks is, well, what does that mean? And basically, it means if you're in one of these 3 situations, you are both mentally and physically incapacitated, and your primary physician and a secondary treating physician have determined there's no reasonable probability of recovery from that condition. And you have said, you've initialed next to one of those conditions that you don't want life-prolonging procedures, they will either be withheld or withdrawn in that situation. So how has this evolved with the coronavirus is what I think we're concerned about, right? So COVID's had a pretty big impact on our thoughts regarding the living will. And first of all, the urgency for creating one. I think everyone needs one if you don't already have one. It's important to note that putting a patient on a ventilator would likely be considered a life-prolonging procedure. And so pretty important to decide at what level you would not want that to take place. And so right now, I mean, where we stand, we don't really know how medical professionals are going to interpret the living wills. And so because of that, we're adding language to your living will that directly addresses COVID-19 and whether you want certain life-prolonging procedures to be used until it's determined that there's no reasonable probability of your recovery. So we're building some language in there that can give you a little bit more comfort with addressing that specific issue.
Okay, so we understand these healthcare documents, but if I'm incapacitated, who is allowed to make decisions about everything else with respect to my affairs?
So that's also a great question. So the person who makes all of the other decisions for you is your agent, and that is named in your durable power of attorney. So again, oftentimes spouses appoint each other as agents for the other. Adult children, siblings, parents make great backup choices. And for this particular document, because it's so powerful, oftentimes as the backup, it's not a bad idea to have co-agents to have some checks and balances and make sure there isn't one agent that's going to run off to the Caymans with all your money. So the durable power of attorney is a very powerful document. It's important to have one in place, because if you don't have one, then it's difficult to access your financial affairs without an agent appointed. And that's even when you're married. So just keep that in mind. If it's not a joint account, it's an individual account, there can be issues there. So it's important to know that this document can also be abused. It's probably one of the most abused documents that I come into contact with. And here's why. When you sign your durable power of attorney, it becomes effective immediately. There's no triggering mechanism. It just means that your newly appointed agent can sign on your behalf on financial documents. They can sign on real estate contracts for you, which is super convenient, but also kind of scary and dangerous. So your agent is only supposed to act with direction from you or in your best interest when you're incapacitated. But sometimes agents only act with their best interest in mind, and that's why it's super important to pick the right person or people to serve as your agent. So oftentimes where I see things happening is it starts off innocently, where we have maybe an adult sibling that's serving as an agent, and they start being the caretaker for a parent, and they start kind of doing all of the work and feeling like, man, I think I'll just pay myself a little bit for doing all this hard work. And then they start changing beneficiary designations on bank accounts, maybe leaving out the other siblings so that they inherit more than the other siblings. So that's when things get really tricky and scary, and that's when we bring in our litigation team, because that is something that we need to address quickly. Okay, not going to stay focused on that issue because that's a downer, but the powers in the power of attorney are very helpful. They allow your agent to handle your financial transactions, including banking and investment transactions. They can work directly with your financial advisor if you give them the permission to do so. They can handle real estate transactions, which can be super convenient if you're out of the country or out of town. They can sell or lease your real estate on your behalf. They can handle your personal property, so they can host a garage sale for you. They can even continue your business operations. And for this one, if you're a business owner, I like to include pretty significant language here that allows your agent to kind of step in and make some important decisions as necessary. If you're not, then that is not quite as an important section. But the agent can also handle insurance claims on your behalf. They can handle a lawsuit. They can settle a lawsuit. And they can even enjoy preparing your tax return. So pretty much anything you can do for yourself, your agent can also do. So there are some other powers that are considered super powers, which must be initialed by you before the agent can use those powers. And so when I meet with clients, we go through each one of those superpowers individually and decide which ones are appropriate for them to initial and which ones maybe aren't, depending on who their agent is and what their specific circumstances are. But these are called superpowers because of the broad way that they can be used and abused. And so our legislature got together and said, you know what, these are such powerful powers that someone's giving to an agent that we really want to make sure they understand what they are before they give them away. And so superpowers include allowing your agent to change beneficiary designations on life insurance policies, investment accounts, retirement accounts. They can update rights of survivorship on bank accounts. And so these things can be super useful if you need these designations updated, but they can also, kind of like I was talking about before, they can be abused by the agent that's naming themselves instead of who you want to actually be named. So these are one of those powers that you may want to use caution and think carefully about who you're appointing. So with your authorization, your agent can also create a trust on your behalf. They can amend a trust and make large gifts on your behalf. They can make gifts to get you qualified for Medicaid. They can access all of your digital assets, accounts, and devices. Again, very useful powers in the right hands, especially those digital assets and accounts. I think sometimes people want their agent to be able to go in and make updates to their social media accounts, letting people know, what's going on in their lives. And one thing just to keep in mind is this power of attorney is only effective while you're living. The document dies with you. So sometimes people always start reviewing this document and they're like, oh, okay, well, so after I'm gone, they can go in and close all my accounts. It's not like that. It only works while you're alive. So they can make adjustments to your accounts while you're living, but once you're gone, they no longer have any power. So where are we? So again, just think about these powers, be careful, think through each one and discuss whether it makes sense for you to give away that power. Because as we know, if an agent absconds with your bank account and escapes to the Caymans, we can sue to recover from their wrongful act, but we all know that that's super expensive and a difficult process. So if you only know one person who you would trust to be your agent, I wouldn't be over concerned with trying to find a backup just to have someone to fill in that place. That's something that we could address later. Finally, so one other kind of convenient thing to know about the power of attorney is that this isn't just for when you're incapacitated. So I've had clients who are grieving the loss of a husband and they just don't want to do the stuff. They don't want to pay the bills. They don't want to deal with a financial advisor. And so they say, you know what, agent, I'm giving all of that to you. I want you to do all of this right now. And it gives them the ability to grieve, to spend time just focusing on the more important things in life. And so once they were able to take over again, they did. And I think it's a nice thing to be able to have. So you don't have to be incapacitated and in the hospital to have to receive those benefits of a power of attorney.
So Amy, what if I already have these documents?
Yay! So great. But again, you should take a look at them and make sure that they still meet your needs. Sometimes people come to me and they're like, oh yeah, I did this back in 2000. I'm like, great. Do you know that was 20 years ago? So anything created, especially a durable power of attorney created before 2011, really needs to be reviewed and updated because there were major changes that happened. And so while the documents created before that would be considered legally valid, they would certainly be stale. And should be updated. A lot of times they get criticism from banks when they're older than 2011. And for the healthcare surrogate, really anything before 2015 should be updated. And now that we're dealing with the coronavirus and the issues surrounding that, I think it makes sense to probably take a look at them again. Updating to include language allowing a healthcare provider to communicate via phone and email. And just a good time to kind of take stock of what's important and follow up with your attorney.
Great. So all these documents we've talked about so far are for use while we're living. How do we make sure that it's clear what we want to happen to our stuff after we pass away?
Well, so this is where things get interesting because there are so many different ways to transfer assets at death. Everybody's needs are different. I'm going to summarize kind of the basic options and just know that sometimes we use a combination of these methods and there isn't really one sure and fast right way to do it. I think it's just paying attention to where you are in your phase of life and, you know, are you a young professional that's single with no children? I think it's a different approach. If you are married with small children, it probably is the most conservative approach. And then if you're in retirement and you have adult children, or maybe you have no children and you want to leave everything to charity, there's a lot of different situations and phases of life that we have to address. So the first thing I usually start with is looking at a simple will. A will is oftentimes called a last will and testament, because you are the testator. It's a legal document that allows you to detail your wishes of where you want your assets to be distributed upon your death. So this allows you to appoint a personal representative to administer your estate. It also allows you to name guardians of minor children. The personal representative is tasked with bringing that will to the probate court. So in Florida, you're required to hire an attorney, and that will is subject to probate. The court reviews and accepts the will and then appoints the personal representative in accordance with your wishes, so long as that personal representative is someone that is able to serve. So carefully choosing who that personal representative is kind of important. It's an administrative process to go through probate. A lot of people hear all kinds of terrible things about it, and some of those are true. It can take a significant amount of time before distributions can take place, sometimes up to 12 months, sometimes longer if there are disputes among beneficiaries. But sometimes it can be very simple. It's just a matter of going through the paperwork and filing what you need to file, making sure that creditors are aware that they can make claims against the estate, and kind of just following the right steps to get through that process. So a simple will can be a great effective tool to distribute assets. And sometimes we use a simple will to distribute certain assets and other methods for other assets. So the next one, slightly more complex, would be a simple revocable trust. Similar to a will in that it controls distributions of assets at your death, but it's a little bit more complex because it can hold your assets during your lifetime. So I like to think of a trust kind of like a box. And you, the grantor, the creator of that trust, get to place your assets into that box or designate life insurance to go into that box post-death. And then while you're living, you as the initial trustee control all of those assets. You do with them as you please. And then after your death, a successor trustee that's named by you distributes your assets according to the terms of the trust. So for families with young children or adult children with spending issues, a trust can be a great tool to distribute assets at a slower, more controlled pace. You can stagger them out, every 5 years post-death, or at certain ages. It all kind of depends on your situation, but it gives you a lot of control. It gives you the ability to place some hurdles in place before beneficiaries can receive all of the distributions. Trusts can be relatively simple to extremely complex. They can have multiple layers that include tax planning and charitable planning and giving. And so that's probably a topic for another day, but just wanted you to have a good idea of what a trust looks like and kind of when it's appropriate. Beneficiary designations, pay on death, and transfer on death accounts. These are simply named designations on your accounts, investment accounts, retirement accounts, life insurance, bank accounts. And when these institutions are presented with a death certificate, those distributions get made according to the designation. So there's usually a primary beneficiary and a contingent beneficiary, and it is a very simple, quick way to distribute assets directly to a beneficiary without the use of a will or a trust. The pro is that it's super simple and quick. The con is that it's super simple and quick. And so if you have beneficiaries that you're concerned about how they might act with inheriting a large sum of money all at once, it's probably not the best way to pass your assets. You probably want to choose a different method. One other thing is to make lifetime gifts. And so this is just what it sounds like. You would gift assets to your loved ones during your lifetime. So this isn't exactly post-death. This is more of a yearly gifting strategy. And as long as it's under the annual exclusion amount, which right now is $15,000 per year per gift, you can make that gift without filing a gift tax return. And so lifetime gifts can be very rewarding. So you get to see your beneficiaries, your family, your friends, your loved ones, kind of enjoying the benefits of that gift while you're around. And so, so usually this is done in combination with other methods of transferring assets, but just something to think about that that can just be a nice thing to do. So one more thing that we've kind of already talked about is that documents should be reviewed every 5 to 7 years, sometimes earlier if there's a major life experience like a birth, a death, a marriage, a divorce, a disability, all within the people that are named in your documents. So it's not just something happening to you, but possibly something happening to the people that you've named. And so, and then if there are major law changes, then you would most likely hear that from your attorney that you should probably update documents. So that's kind of it in a nutshell. I'm open for questions if people have them.
Thank you, Amy. Lots and lots to think about, especially now during these, what we like to say almost every day is unprecedented times.
Oh my gosh.
And lots of ways to protect your loved ones and your assets and to make sure that things are done the way you want them to see them done. Do you have any closing comments? I'm looking to see if we have any questions at the moment. We don't. Do you have any closing comments for our audience?
You know, I don't really have a whole lot more to add except to pay attention and update your documents. And if you don't have them, then it's probably a good time to get them.
Great. Well, we really appreciate your expertise today. I know that you are very busy, especially now with lots of requests from people trying to get everything organized. And this is a great, I guess this is a silver lining of where we are right now, is that it's a call to action for a lot of people to get their affairs organized, as well as, like I said, your closet, maybe your garage, maybe every other compulsive area of your house that needs tidying, like it is at mine. So I really appreciate your being with us today and sharing your expertise. We want to let you know about what is coming up. On May 18th, I'll be speaking about what we can do to help our business community navigate this next stage of recovery. The topic is called Help Us Help You, and we would love to be able to articulate for you the ways that you can use your chamber membership and the role that the chamber is playing in this 3-step process where we began meeting emergent needs, and now we're going to start to assess further and ongoing needs in our local economy, and then we're going to begin that important work of recovery and hopefully getting back to some place that's even better than where we were when this pandemic emerged. And then on Wednesday, May 20th, we'll be hearing from Betsy and John Hughes, who own the Track Shack. And that will be the Hot Seat Academy webinar, where we will become inspired by local successful entrepreneurs on their entrepreneurial journey. So next week is a change. We'll be dropping down to 2 webinars instead of 1 every day, Monday through Thursday. And we will be dropping down to communication on Monday and Wednesday only. So this is the sign that we're starting to move out of the emergent stage of our crisis, and we will continue to communicate as needed, but we will be having content on Monday and Wednesdays only. So we look forward to having you follow us next week. We will continue to focus on member news and the news of our businesses, changes that they've made to their operations. We will continue to communicate that. We'd love for you to follow us on social media, LinkedIn, Twitter, Facebook, and Instagram. And then also to receive our newsletter, go to winterpark.org and fill out your email address. We do want to extend a thank you to Swan Hadley, Stump Dietrich and Spears PA, and Amy Collins Hitchner for being our speaker today. Enjoy your afternoon, and thank you for being with us for this webinar series.